Hello and welcome to Passing the Bar, a video lecture series brought to you by Delaware Law School. My name is Professor Brett Bendistis, and today's lecture video is going to be covering a very particular part about MEE essay construction. And what we're going to talk even more narrowly than that is the idea of the application/analysis section of your writing, meaning when you're taking these essays, how do you make sure that you are best effectuating the part where you are applying facts to law to justify your conclusions? Now, we talked about the last video, the idea of IRAC and CREAC, right? Certainly there's some differences, and I'm not going to say that they're exactly the same, but the idea in the most part of like the way you're putting your bar exam, your bar questions together is that you're compiling a collection of rules and then you're applying the facts to those rules to justify your conclusion, right? However you're doing it, that has to be done, right? So the thing that I want to talk about a little bit today are what are some common issues that I've been seeing with application sections, and just a few like really easy suggestions and thinking about how we can fix them. That's really the key. I don't want to be someone who just is like, yeah, this is a problem, without showing you some easy ways to think about it, and maybe, you know, with the next month that you have, having a way of preparing yourself for the bar exam. Now, when we get into this section particularly, I want to kind of talk a little bit about my own experience taking the Delaware bar exam particularly, and how that kind of influences an approach that I may have if I were you and you had about a month left before the bar exam. So the first thing that I would suggest is think about the idea of looking at your calendar, right, where today is and where the bar exam is, and finding at least one, if not a couple days, where you can say on this day, July 18th, right, July 20th, whatever it is, right, and say that's the day where I'm going to take a bar exam. I'm going to wake up and take the bar exam in the exact circumstances that I might do under the real bar exam. For example, here's going to be my point. It's easy to say, well, I'm going to do half the essays on Saturday, the other half on Sunday. Well, that doesn't prepare you for the experience of what it's like taking it all in one shot. Maybe you're going to say, well, I'm going to do it on my couch. I know the story I'm about to tell you is that I did it on my kitchen table. But think about the idea of like what it means to like take a big, long, really life important essay sitting next to a bunch of strangers, right? What time is it going to be? Again, what are you going to eat? What are you going to drink? How are you going to prepare yourself to be in the right state of mind to take the test? And so one of the things I might think about is saying, all right, on this date, I'm going to take the bar exam at 9 a.m. Maybe what I'll do is I'll drive to Delaware Law School and I'll take it in the library, but I'm going to mimic the exact circumstances so I'm familiar with what I have, right? That's point one, right? The other point I'll tell you is that when I did the Delaware bar exam, I took Pennsylvania, New Jersey first. I focused mostly on the MBE because that was the thing that I was most nervous about. Delaware in particular, the story that I'd always heard from my friends is that the reason why they didn't pass the bar exam, like the most reoccurring theme was that they didn't finish, because I thought Delaware was a fast bar exam. It was very quick. I'm going to show you a Delaware bar question and show you the level of like detail that has to be put into these. And so one of the things that I did more, I'd say more so than I did the first time, is took a lot of timed essays for this one particular purpose. I realized that like, given my druthers, I would write all day long, right? I would talk all day long too, if you might could already tell. But the big thing that I think was important is that like I was always the last person to leave every single law school exam. Like if it was 4 hours, they had to kick me out of the seat, right? Can't do that on the bar exam. And so one of the things that I was practicing is the idea of how do I make sure that I take up all of the time, not less, not more, to give as much information as humanly possible. Because one of the things that I sort of felt like is that I wanted to be consistent with every single question. I wanted to give every question the right amount of attention so I wasn't getting stuck. And the more I took practice essays, the more I found the groove of seeing certain questions where I would say, all right, well, if I'm going to take a Civ Pro question, and if there's a personal jurisdiction point, well, all right, I'm going to give that a little bit more attention, because I also know that there might also be, let's say, a joinder question. Joinder questions, right, folks? But the idea being that, like, I know that, like, this is big, this is a little bit smaller, right? So the point being ultimately that trying to prioritize what needs the most attention and how do I give things the most amount of attention, and that takes a little bit of time. You've never taken the bar exam before, and even if you have, like, it's a one-time, very particular style of writing, and even like in the future when you practice the law, you probably won't have to write really complex questions in 45 minutes. That's not a great way to bill hours. So the point being is like take this for a very particular skill that you have to hone very particularly. One of the things that I also find, again, teaching legal writing for a long time, is that sometimes you go too far and someone's like, you got to write less. So then you write less and someone else says, well, you got to write more. And it's not a matter that it's all or nothing, but sometimes it's like, where's the sweet spot in the middle? And that takes a little bit. Sometimes you have to give a lot of feedback and find it out and kind of learn it on your own. So if you are getting frustrated with the process where someone's saying you're writing too much and then you're writing not enough, that's good. I mean, as long as you're able to be flexible and you can kind of see where it's meeting in the middle. Obviously, if you're frustrated, you can always email me. My email address is right over there, and I'm happy to help. But the point being is that, like, take it as a process of, like, this is different. You can't kind of come in and assume that you know how to do it. Take the time to kind of work it out and make sure that you're doing the things that you need to do, right? Learn the new skill that comes from doing this here. Now, we're going to cover 4 really particular points. I'm going to go over 3 samples that we're going to cover. We're going to talk a little bit about a few different ways to approach analytical writing. So I'm going to talk about a few of these points, go through a sample, cover a few more points, and do it again, right? Kind of bounce back and forth. The main thing I want to talk about first, I want to go to the second point, which is analysis over storytelling. The main thing I want to think about is the idea of, are you writing with a focus on conclusions, right? Or are you writing the facts and assuming that the bar examiner will know that those facts are supposed to go somewhere? You know, the best way that you can structure your analysis section is that every single sentence is, this law is proven because, right? It is also proven because. I have often found that, like, when that's sort of struggling, when, like, you know, think of this question to yourself. Do you find that you waste more time writing rules or writing application? If the answer is writing more application, I think you need to simplify your structure and have the same sort of mechanics that you do with your rules. You know, a lot of the times people are like, well, when the rules come, I just, you know, regurgitate what I have. The application should be comparable, in that the idea is that you're just taking every single rule, and this is proven because, this is proven because, this is proven because, using the buzzwords and making them clear. You know, the thing that I often found about legal writing is that I write from the perspective that the person who's reading is not as smart as I am, or doesn't know as much about this as I am. And so I have to convince this person that I am correct. I write always from a place of confidence. One of the part about analysis that is important is that, you know, this law is proven because of obvious things is still a part of legal writing, right? The sky is blue because outside it's the color blue. That sounds so simple, but that's a lot of, like, what makes up the bulk of a lot of these questions. Being able to see that these obvious facts prove this really important legal conclusion is a really important thing that I think bar examiners probably want to see when they think about the idea of whether you can approach the problem like a lawyer, right? It's not just a memorization quiz, it's not getting the answer right. The big thing is being able to compose your answer and be able to structure it. So that's going to go through everything that we're talking about today. The other point I want to talk about is the idea of consistency. And I'm going to jump into a quick question, a sample answer here, to show you a point of thinking of it is every single point of comparable length and detail. That's the thing that we're going to cover right now. Now let's cover some preliminary things with this essay first. I just want to talk a little bit about how it's organized. I want to cover the topic. Now we're going to talk about a contracts essay here, and this is a very particular Delaware exam. The way that you sort of know that in general is that it is a contracts question, and then you see you have A, so every issue is going to be organized with, like, bold-faced and letters, and you go all the way down to E, so you've got 8 different questions that deal with contracts, which is a little bit intimidating when you sort of open up the book and see how it's organized. Now, the thing I want to note about is something like this is what I'm going to do is I'm going to underline all of the rules, and then I'm going to have the application section later. Now, to me, the best way to organize the bar exam, and this is just my own preference, is that you include the issue and the rules together, and then you include the application and the conclusion together. Now, you may note that this paragraph right here, there's a dividing point where it covers a new point of law, right? You've got goods being under Article 2 of the UCC, and then you have it sort of getting into contracts. I would prefer, personally, if those were still organized in the same way. The problem I find with having subdivisions there is that when I'm reading rules and then there's another paragraph, my anticipation as a lawyer is that I'm going to get into the application. And so I know this is probably silly, but it's the kind of thing where you are unduly confusing a person who's reading it. I think trying to keep those rules as clear as possible, unless you're using an umbrella paragraph and you're covering individual elements, try to keep that a little bit more uniform, because I think it helps the reader understand what it is that you're trying to cover. Now, I want to kind of give you a big picture overview of this. And if you have an essay that looks like this, I want to give you some suggestions to really think about. First thing you'll notice, you've got two pretty sizable paragraphs here to answer this question, which I think is solid. Here, then you have a very significant rule paragraph with a much shorter application paragraph. I think the problem that you're going to run into there is you probably got some rules that you're not covering in the application. We're going to talk about how to shave that down in just a quick second. Then when you start getting here, you start noticing that like shorter rules that aren't terrible, but then the application is just really a sentence. You have a little bit more substance here, and then we're starting to get into much shorter rules, much shorter application sections. One of the things that I would really suggest thinking about is you're starting to study essays and you're really starting to organize and practice the timing of your essays. It's trying to get through the first couple questions without this really in-depth level of analysis. The problem with a question like this is that you have 3 out of 8 questions that have like a pretty substantive amount of content, and then you've got 5 questions that have less content. That's a balance that you've got to strike, and you've got to figure out a better way to narrow things down, because I think you'd rather have consistency through every single question than have a few that are really heavy and a few that don't have anything at the end. Although you might say, well, how am I supposed to include everything? Well, people do pass the Delaware bar, and so I think it's a matter of getting into this idea of, if it's a time constraint for you, it's going to be a time constraint for everybody. And it's not a matter that you're a bad writer or you don't get anything, but I think it's more the idea of figuring out the way of how do you tailor your writing for these time constraints. One of the things, like I said, is like the bar exam is different than anything else. It's not like, anything that you've either had to have written before or you're going to have to write again. And so taking the approach here of, okay, well, if I have an offer question, right? We look at this topic sentence. The focus is clearly offer. Well, then I don't know that I really need something like this in particular. I don't, you can certainly include the UCC in the common law, but the point is that like this is the primary focus, the idea of really getting into the idea of the objective manifestation of a present intent to contract, reasonable expectation, right? Those things have to be the focus, so they have to be the comparable focus in the later section as well. Similarly here, you see a lot of really good content about acceptance, and that's fine if you've got the time for it. I would probably have no problem with this if every single question was consistently as thorough as this one. However, when you see that later questions aren't getting the same level of detail, that to me is where I think the value comes in repetition and practice. You can then kind of shorten it to note, once again, this is clearly just about acceptance, right? So if this is just about acceptance, tailor your rules just to that acceptance and don't worry about including all the other content. Like if the mirror image rule isn't relevant to the problem, well, then you don't need to include the mirror image rule in the context of things. That'll help tailor not only this part down, but I think it's going to help really kind of explain and govern your application section. One of the things I'll note here is that you've got an application section which does give a really strong answer. It's got a great topic sentence. It talks about here, objectively manifest a present intent to contract. The only point I would note is that the rest of these sentences have to match that a little bit clearer. It's not objective because. There's not present intent because. There's no reasonable expectation because. All of that content's there, but I have to squint a little more than I'd like to. And so one of the things I would think about is that if you're struggling where you're looking at it and saying, well, I'm prioritizing application over rules, that's what's taking my most time. Simplify that writing process so it's just conclusion, 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 and you don't find yourself just sort of, and again, I do this, like sometimes I write the same thing 2 sentences in a row. That was a big thing that I had to sort of tailor as I became a lawyer, of saying I can just say this once and it's okay. So this is going to be my main point of thinking about the idea of limiting these sections if you find that your essays are like top heavy, right? They start really substantively and then they kind of at the end lose that same level of focus. The point I would also note here is that when you get into questions like this, right, you've got a good amount of rules and then your application is a little bit shorter. What I'm going to note here is that These are application sections that kind of default to something that I very commonly see is that when you're pressed on time, sometimes people sort of focus on facts, but without sort of adding this little extra point that I think would give you, again, that little bit of extra information that you need. You're talking about the statute of frauds. You're talking about that it's got to be performed within a year. The answer here does generally make sense, right? There's 9+ years left in the contract. It couldn't be performed in 1 year. The new agreement had to be in writing. But these are just, they don't have the same analytical focus of just saying the statute of frauds is not satisfied with this contract, right? This contract cannot be performed within 1 year because there are 9 years later. This is super obvious, but it's the kind of obvious nature that you've got to include. Because the statute of frauds is not satisfied, it has to be in writing. It is not in writing, therefore is invalid. Right? I'm going to go back. I'm going to double check my spelling. I'm a terrible speller. Computers have saved me. We're saying the same thing. I haven't said anything substantively differently, but every one of these sentences has an analytical conclusion attached to it. I'm not just restating the facts. The one fact that is important follows a because, right? And it also, because it's not satisfied, it has to be in writing. It's not in writing, therefore it's invalid. So one of the things that sort of is here is that, like, I've written this in 15, 20 seconds. If I had more time, yeah, I might fix maybe that third sentence and make it slightly more analytical. But the idea being is that when you're pressed for time, the law is proven because the law is proven because, try not to panic. Have a plan for when you panic, because that's going to give you a better approach where you're going to get, again, those little points when you're losing the trouble that you need. So the next one I want to get to is talking a little bit about analysis over storytelling and talking a little bit about symmetry. One of the key things that I talked previously was the idea of, like, when you've got a rule, apply the rule, right? But another thing that I think often comes up is the idea of, like, well, how do I know what I'm supposed to be doing? And what if I don't have enough material to include it? What if I don't have the material that I really need to kind of like substantiate it? And one of the things that I like to kind of cover, and I talk about this a lot in like Legal Methods 1, is that if you feel like your application section doesn't have enough substance to it, what always helps a good application is like more rules, right? More rules are always going to lead to more application. And so I want to kind of show you another essay to talk a little bit about the idea of how we can take an answer that, again, is technically good. It's got the right law. The person saw the problem. But how do we take something that I would think a bar examiner may have an issue with and add a little bit more substance to it by just sort of like seeing a little bit more law, seeing a little bit more of the fact pattern, and add a little bit more substance overall with the entirety of the problem. Okay, so this is one of the few times that I'm actually going to show you the question, because I think the question here actually is indicative of, again, how to bolster the application section of your paper, right? This is a criminal law procedure question. It's an NCBE, it's an MEE question from July of 2015. So if you can reference that, if you know where to find them, they're really good questions and they're a good way to kind of practice. Key facts I want to show you is right here, right? You've got a man who's in a car, a woman takes a knife from her backpack, holds it against his throat. She says, "I'm being followed by photographers from another planet where I'm a celebrity. Pictures of me are worth a fortune, so I never give them away for free. Forget the speed limit and get me out of here fast or else." She holds a knife to his neck. He speeds really fast. He ends up killing somebody. She later is in custody and she's examined by 2 psychiatrists. They submit reports saying that she suffers from schizophrenia. At the time of the accident, her delusions about alien photographers were caused by schizophrenia. She's charged with felony murder and she is presenting an NGRI defense, and you have to explain it. Let me come back here really quickly because I'm going to talk about something that's really important with that fact pattern, and it's really important with all of the fact patterns that come up. That is an easy thing to look at when I think that when you see a problem and you go, all right, cool. It's an insanity defense question. We all learned about the insanity defense at law school, but there's a few really particular sentences within there that are really vital to really kind of understand the focus of where the problem is. I'll tell you what the sentence is in a second. You can think about it a little bit. I'm building to suspense, so to speak. But one of the things I think a lot of people ask me about is, like, how do I work on issue spotting, right? Very normal problem. And I think there's 2 approaches I would have. First off, there are going to be times where you miss an issue. It's a drag and it's a bummer, But if like you can avoid it as much as possible, it won't sink your entire bar exam life, right? Like at the end of the day, like if you miss an important issue, again, you really like to avoid it as possible, but it does happen, right? So the key thing to note is that like it's avoidable, but again, don't like shoot yourself in the foot if like you're missing them here and there. The facts to me are the really important part here, right? Like the idea there of thinking about the insanity defense. Well, what do we know about the insanity defense? Normally, and this is included in the question I jumped away from too quickly, is that you need to have some kind of mental defect and it's got to affect your appreciation of wrongfulness, like right or wrong, right? The key thing about that wrongfulness point is that the first question is fairly established, right? It's unlikely that the bar exam is just going to test you whether or not you know that schizophrenia is a mental defect, right? I don't know that it's even a legal question, right? But the point that I think is more important here is that wrongfulness question. So when we go back and we look at the fact pattern, we're noting a few things. There's a knife. There's a version of where or else. There's also a really important sentence there that says that like ignore the speed limit, right? I know what I'm doing is wrong. Those are the kind of things where yes, you want to get through these facts, but those are the kind of things where I think if you've got a more watchful eye, if you can be the world's greatest detective and you can see those questions, that's a little bit of where you add to the analysis. So one of the key things is I'm going to show you a sample here, and we're going to give you an example of one that I provided that again memorizes it, gives the law, lacks the substance, and we're going to talk a little bit about how to add the substance with available material to make sure that again you're raising the floor on the material that you know, kind of like raising the ceiling also. So a bit of a shorter essay here. So what we're going to do is we're going to cover the idea of the same thing. You've got your rules first, your application section, right? First thing I want to note here is you've got your rules here that just give you a broad state of the rule, and then you have your application a little bit later on, right? So the rules here that I want to note is that the problem that I think you're running into with a rule statement like this is that yes, this is the applicable rule. The problem that you're running into is that you're not defining the key point of what the rule is asking for. For example, this idea of whether or not you know what it is wrong. I think it's important here to kind of go into your outline and being able to provide something that shows this is how the law establishes whether someone knows that something's right or wrong. You know, I always find that the thing that I've learned more as a lawyer is that when there are terms of art, really specific legal terms that mean something, the more narrowly I can define it, the more successfully I am. Meaning that it's not going to come up to a judge of whether a judge thinks that something is right or wrong, but more along the lines of like, where can I really direct the reader's attention to a very specific legal definition? Because the point I want to note here is that your application section here focuses more on the first part, the mental disease or the defect, and it doesn't actually address the more specific part of the question about that wrongfulness. Now, when you're not sure about the wrongfulness, that's a really important part where if you can add more material later on, that gives you the answer that you're really looking for. So if you're struggling for application, adding more rules and adding more detail there leads to more application. If I can scroll down, right, there we are, we're going to scroll down right here. I've added a few sentences to give a better hand of adding the rules. Defendant's understanding of the wrongfulness is the key element which eliminates criminal intent. Delusional acts only satisfy the standard if they affect defendant's understanding of wrongfulness, and it's defendant's burden to prove both elements of the insanity defense. A few reasons why I have those. First, I'm adding a little bit more content to the importance of wrongfulness. I'm noticing the idea that delusions still have to establish wrongfulness, and then I'm including the burden just so I can qualify the question a little bit more specifically. So the idea here is that what I want to be able to do is note the fact that it's defendant can meet, defendant can't meet. To me, that's a better idea of showing practical legal writing and practical legal analysis. Whose burden is it to prove what and proceeding from there? You'll then note that my application sentence again starts with my conclusion. Defendant will not be able to establish the insanity defense. Defendant can meet the first element because the treating doctors determined she had schizophrenia, which caused her to have vivid delusions about reality, right? That's an obvious one, but it's a really important part of the test. If she can't prove it, that's a problem. So the first thing I'm addressing is making sure that both elements are established, and I'm saying it specifically. Defendant cannot meet the second element because her delusions did not prevent her from understanding the wrongfulness of her actions. Although the woman believed she had aliens taking pictures of her, those delusions did not affect her understanding that holding a knife to someone's throat was wrong. Her statement about forgetting the speed limit also suggests she understood the rules of the road and requested the driver break those rules. This evidences an understanding that her behavior was wrong, which undermines the second element of the test. And so the key thing is that, like, to me, that's that issue spotting point. Seeing the one that seems to be the more difficult question, making sure we're covering both points, and then adding as many facts as possible to include it. You'll also note the fact that while I'm referencing those things, I'm including them in an analytical way. Forgetting the speed limit suggests understanding the rules and requesting them, breaking them. I'm not just telling you the facts, I'm being analytical of the facts, and that's the key thing that's going to prove my point. Okay, last 2 points, and these are, again, really, really important points that I think distinguishes good from great, and also kind of adding a little bit more points to make sure the bar examiner knows what you're thinking of. I want to talk about symmetry and organization. These are very comparable points. The point I think about symmetry is making sure that the law, the application mirrors the rules. And I think that's a vice versa situation. The case of goose v. gander, if you will. The idea that, like, if you've got rules and you're not addressing them in the application, you're missing something. Right? But if you've got application and you've got rules that aren't being covered, well, then maybe those rules need to leave. And so one of the key points is, like, making sure that everything up top matches everything at the bottom. That's a really, really big point, not only from a substantive point of view, but from an organizational point of view. Meaning, when in doubt, and you don't, again, if you're having trouble figuring out how to write it, how to make the approach, simplify it. Right? This sentence is this sentence. This law is this law. Because what I think that you're going to end up doing is that you're going to make sure that, one, you're being conclusive, but you're also sort of making sure that it mirrors it specifically. That first essay we talked about the UCC and common law, but then didn't mention in the application section. That's either something where you want to include it as just an easy sentence, right? This is governed by the UCC and therefore blah, blah, blah applies, right? Or if you're feeling like, hey, I'm not really covering it, comparable to the consideration in the application section, well, then get rid of that material. So making sure symmetry works is not only from a substantive point of view, but sometimes what you're going to see is, like, if your application's kind of all over the place, making sure that it's built from an organizational point of view, from a symmetrical point of view, will make it easier to read. The other thing that I also want to point out is the idea of, are you starting with your conclusion and explaining why, or are you building toward your conclusion? I often find that good topic sentences are more important than anything else. And I also tend to think that sometimes when again, you're under pressure and you're writing essays, so, like, believe me, I'm extremely sympathetic. But the point I want to note is, like, try to prioritize the idea of giving me the answer, then saying why. Like that last criminal law question, element one's proven because, element two's proven not because. Don't tell me why and then give me the answer. Invert it. I think what you're going to find from inverting it is that it's easier to follow. That's the main thing that we want to get with bar examiners, that we want them to see your question and say, well, this person gets it. That's with good topic sentences. That's with application that's top down, right? Organized symmetrical material. So let's talk a little bit. We're going to go to another essay. I'm going to show you something of how to break something down. And again, this is something I would ask that you do with your essays. Because what I think that you're going to find here is that when you can see the problem, it's going to help you out. I apologize if I've told this anecdote before. I do this a lot, right? I've told a little bit of a story of the idea of a friend that I play board games with. He's somebody that I do my podcast with. My podcast, The Citizen's Guide to the Supreme Court. We have a wonderful episode on the most recent Supreme Court cases if you haven't done it. But what happens is that he and I play board games together, and he always wins. He's always like, well, I don't care about winning, but he does, right? But here's the bigger point, is that when we play something new, I try to learn how to play, and he learns how to win. And that's the difference, is that I'm just trying to figure out what the rules are, whereas he's learning, like, strategy, right? I want you to think a little bit about the bar exam where, like, learning the rules is studying the law and getting the answer right. But, like, learning how to win is like approaching the questions correctly. And again, you've got a few weeks left. If you've been following your bar prep program, you should be on a pretty good path there. So whether or not it's essays or whether or not it's NBE, I want you to think a little bit more big picture of, like, how do I approach these things and how do I look at what I'm doing and really fix my mistakes more specifically?
That to me is, I think, something that we're going to talk about here. It's the big focus of what I want to have for the rest of the lecture video. All right, so this is a civil procedure question. And what we're going to do is we're just going to talk about organization and structure, and we're just going to try to improve upon the idea of how do we put our best foot forward? How do we know the law? We know the conclusion. How do we make sure that it's written with a level of clarity that gets us the most amount of points possible? The first thing I want to note is you've got a rule paragraph that I think is pretty good clarity, structure, tone, and organization. You have the point up here in the first couple sentences that just talks about location and domicile. That's perfect, right? You then have the idea of actions that can give rise to jurisdiction. You have service and you have committing the act. And then finally, you have the test here that deals with minimum context, purposeful availment in the Constitution. That's a very easy path to follow, right? It gives you step 1, step 2, step 3. The point about organization and structure is making sure that all of those points are covered and that they're subdivided with really clear topic sentences that make sure they're clear. What you have here is an organization and an answer that I think gives the right answer, right? The fact that you've probably, you need to qualify under state B, for state A under the long arm statute. You probably have to analyze the idea of the facts where the conference was held, where the harm took place, and you have to have a good amount of discussion. The problem that I think comes up is a matter of, are you directing the reader's attention in the way that you need? For example, you have this sentence here that talks about how the corporation is domiciled in state B, and that's perfect. But I also tend to think that you have to qualify at the very beginning that the idea that this is important because of what it means for state A. So even if it's something as simple as just simply saying, personal jurisdiction under state A is either complicated or has to be under the long arm statute or is not automatic because the domicile state is state B, just gives the direction that you need. I also think that you've got a sentence here, right? Personal jurisdiction is proper if the harm giving rise to the suit occurred in the state. Well, that restates the law but doesn't give me a conclusion. So I think that what you want to do is requalify that sentence to make it conclusory. Personal jurisdiction is proper because the harm giving rise to the suit occurred in state A. Then you can talk about the harm that's being done and you can qualify it. The point that I would also note here is that there's a list of facts, and these are all really important facts, right? Where the conference is, where the statements are. That brings up the point we talked about in the criminal law. You're seeing the issues, but I also think that you want to clarify where the issues are important and maybe where they need, where they can be organized differently. For example, I think that the most important thing about harm is talking about the rest of here, inducing the faulty solar panels and the comments of misrepresentation. While that applies with the harm, I think the fact that the conference was there, that they availed themselves, is a different conversation. And so there has to be some kind of subdivision to make sure that this point here about it being purposefully availed, you have the division between the harm and the minimum context to make sure those tests are clear, because you're addressing the points in the right way, but they're not organized in a way that I think best puts your foot forward. It takes you a little bit to squint to really see them. The point that I would note here and a suggestion I would make after your assignment is done, after you've timed it and after you've looked at it, is break down the rules and break down the application by points that you're making. For example, right? I would take every one of those rules and I would subdivide whether or not these rules are organized in a way that I think makes sense, right? And I think that this is kind of consistent with what I had mentioned before. But when you go down here, taking your application and subdividing, I think you can see the idea that there isn't enough conclusions that really kind of give me the best foot forward in where I need to put everything. There's no conclusion here at the beginning, where again, qualifying that is why it matters in the beginning, I think is important. I think adding something here about harm, but then also sort of subdividing this point a little bit more clearly is going to give you a little bit more detail and analysis. So again, by doing this, the corporation purposely availed themselves. I don't think that's the right way to put it. I think that you have to say minimum context is proven because, purposeful availment is proven because. And I think that lets the bar examiner know that you know where the facts match up with the important points of law. Finally, I'll note here that you have a discussion on the Constitution, but it doesn't quite get into the substance that's necessary for these points right here. So comparably, like in the criminal law question where we talked about how do you add law to add more facts, adding a better discussion about fair play and substantial justice will give you a little bit more benefit. So to me, I think this is someone who probably would write an essay and say, why am I not getting a perfect score? And I think it's not about memorization. It's not about conclusion. It's not even about issue spotting, but it's Organizing the points so it's conclusion, explanation is going to bump that score up and give you the things that you need. Okay, so main takeaways, right? Application sections are important in a few different regards, and I want to think about what are the things we can move forward with. First, I think that this is something that you want to look over the same way that you're looking over MBE questions. I think everybody takes the approach of saying, well, I double check my MBEs when I'm done. Sometimes I think of it a matter of taking an old essay and actually rewriting it. I know that sounds insane, but I think in a lot of ways, taking the extra time and saying, is this sentence the right way? Am I going over it in a manner where I can rewrite it for my own benefit, right? So I'm getting used to the idea of I'm familiar with the law, I know what the facts are, but I'm double checking it to, again, making sure I have the structure and the organization. Practice is obviously important. It's going to help with consistency. It's going to help with symmetry and organization. And I also think always making sure that you're looking at every single sentence. One of the best pieces of advice that somebody gave me a long time ago was reading your paper backwards by sentence. Reading a sentence, reading a sentence, reading a sentence. Not like reading it backwards, right? But the idea of taking that time and making sure that every sentence is like as perfect as it needs to be. I will tell you that like I pour over sentence structure constantly when I'm writing. Obviously, you don't have the same time to do it, but I think that if you can kind of learn the skills that you need, that way, again, when you go to the bar exam, you've got a good plan, you've got a good approach, and you can be as successful as you should be from the studying and from the conclusions and the things that you're obviously working on in your own time. Now, as we get to the home stretch of the bar exam, I'm going to try to post as many videos as I can to give you a hand. If there's topics you'd like me to cover, please email me. My email address is right up here. If you have any essays you'd like me to review, my email address is right up here. If you would like to talk about anything, or you just need like a super positive dude who can pat you on the back and say, you're going to be fine, that's me. I can do that. My email address is right up here. So good luck with everything. Let me know if you have any trouble. I hope this was helpful. And if you have any follow-up questions, please let me know. I'm happy to give you a hand. Good luck. You're all going to do great.